Alright, Chapter 3, Post-Grant Review, Post-Grant Review, Applicability, Post-Grant Review, Petitions, Preliminary Response to the Petition, Institution, Post-Grant Review, Relation to the other proceeding acts, Conduct of the Post-Grant Review, Settlement Decision of the Board on Appeal. Title 35 U.S. Code 321, Post-Grant Review, Applicability, Applicability, Post-Grant Review, Provisions, Lehigh-Smith, America's Inventor Act, will apply only to patent subject of the first inventor and file with the provision of A, American Investment Act, the United States Code 100, no, except for those provided in American Inventors Act, Statute 18, Paragraph 2. Limitation Director may impose the limit of the number of post-grant review that may be instituted with Chapter 32 of the Title 35 of the United States during each of the first 4 one-year periods for these provisions of effect. Pending interferences, procedure within general, with the director shall determine and include the regulation issued within paragraph 1 with the procedure and with the interference for the commencement for the effective date set forth in paragraph 2A with the proceeding included whether such interference with the dismissed without prejudice found with the position post-grant review under Chapter 32 of the Title 35 of the United States Code, or to perceive the American Inventors Act had not been enacted proceeding by a patent trial with the appeal board for the purpose of the interference with the commencement before the effective date set forth with the parent 2 with the A with the director may deem of the patent trial with the appeal board for the board of patent appeals. Interference may appeal with the patent trial appeal board to conduct any further proceedings within interference with the appeal for the authorization appeal with the remedy with the derivation proceeding section 144(1)(d) of the 146 Title 35 of the United States Code is amended with the act and with the jurisdiction and entertaining appeal with the derivation proceeding section 1295 A4A of the Title 28 United States Code amended with the intro with the deem with the extent of the final decision. Interference commenced with the effect of the date set forth in 2A with the subsection that is not dismissed pursuant to this paragraph. Title 35 U.S. Code 321 Post-Grant Review in general the subject provision of the chapter the person who is not an owner of the patent may file for the office's petition with the instance of the post-grant review patent with the director shall establish the regulation fee for the pay with the person that is requesting review in such amount with the director. It is reasonable to consider the aggregated cost of the post-grant review. Scope of the petition and post-grant reviews may request the cancel of the unpatentable one or more claims of the patent. Any of the ground could be raised in paragraph 2 at 3, section 282, leading to invalidity of the patenting of the claim. Filing deadline of petition of the post-grant review may only be filed no later than the day of the 9 months after the day of the grant of the patent issuance for the reissue, as this may be the case. 320, Title 35 U.S. Code 322 petitions, requirement of petition filed under Section 321 may be considered only petitions accompanied with the payment of fee established by the director on Section 321. Petitioner identifies all of the real parties and interests of the petition identified by the writing of the particular each statement, each claim and challenge grounds in which the challenge to each claim and the evidence of the support for the ground of challenge to each claim, including copies of the patent with the printed publication petitions and reliable support of the petition affidavit with the declaration of support for the evidence of opinion of the petition relies on factual evidence and expert opinions. For a petition provides such information as the director may require with the regulation. Petition provides copies of the documents required within paragraph 2, 3, and 4. Patent owner applicable to designated representative of the public owner and public availability as soon as applicable to receive of the petition under Section 321 of the director shall make petition available to the public. Title 35 U.S. Code 323 Preliminary Response to the petition of the post-grant review petitions filed under 3, Section 321. The petition owner shall have the right to file with the preliminary response with the petition time period with the director that set forth a reason of no post-grant review shall be instituted based on the failure of the petition to meet any requirement of this chapter. Title 35 U.S. Code 324 Institute with the Post-Grant Review. Threshold of the director may authorize the post-grant review the Institute with the director to determine the information presented with the petition filed under Section 321. The information not repeated with the demonstrate with the more likely with at least one claims challenged with the petition unpatentable additional ground with the determination required in the subsection A may also satisfy shown with the petition raises the novel unsolicited solid legal question and important with the other patent application timing. Judge shall determine whether the institute with the post-grant review on the chapter pursuant with the post-patent petition filed under 321 within 3 months after the receipt of the preliminary response with the petition under 323, and no such preliminary response filed with the last day with such response filed with the notice. Director shall notify the petition patent owner writing with the director's determination on subsection A or B shall make with the notice available to the public as soon as practicable. Such notice include with the date of the review shall commence. No appeal determination of the director shall institute the post-grant review under the section shall be filed with the non-appealable. Title 35 U.S. Code 325 Relation to the other proceeding action. Infringement or civil action. Post-grant review barred by civil action. Post-grant review may not be instituted under this chapter before the date with which the petition and such of the review is filed with the petition. Real party interest filed with the civil action challenging validity of the claim of the patent. Stay of civil action petition with the real party with the interest filed civil action challenging validity of the claim of the patent after the day of the which of the petition filed with the petition on the post-grant view of the patent with the civil action shall automatically state it until either the patent owner moved over the court to lift the stay with the patent owner filed a civil action counterclaim against the alleging the petition of the real party interest that has infringed the patent with the petition of real party interest move with the court to dismiss the civil action. 3. Treatment of counterclaim of the counterclaim challenging validity of the claim of the patent of the non-constitutive of the civil action challenge validity of the claim of the patent purpose subsection preliminary injunction civil action infringement of patent filed with 3 months after the date of the patent granted. Court may not stay within consideration patent owner's motion preliminary injunction against the infringement of the patent basis of the petition post-grant review that has been filed in a chapter of such post-grant review with the institute under this chapter joinder. If more than one petition of the post-grant review and the chapter promptly filed against the same petition patent, the director determines more than one of these petitions warrants institute with a post-grant review under Section 324. The director may consolidate such review in a single post-review grant review. D. Multiple proceedings notwithstanding the Section 135A, 251, and 252 and Chapter 30 during the pendency of the post-grant review within this chapter of the proceeding with the matter involved with the patent is before offer the director of the determined manner with which post-grant review of the proceedings may the proceeding include providing statement of transfer, the consolidation, termination of such matter, or proceeding determination of the institute with the order proceeding under the Chapter 30 or the Chapter 31. Director may take into account whether the rejection petition requires based on the same substantially same prior arguments previously presented with the office. Estoppel proceedings before the office of the patent petitioner most parent of the U claim of the patent under the chapter result of the final written decision under the section 328A of the real party interest of the private petition may not request maintain proceeding office for the respect of the claim in any of the ground petitioners raised reasonably could have during the post-grant review. 2. Civil actions other than proceeding with a petition post-grant review of the claim of the patent under the chapter result of the final written decision on Section 328A of the real party interest of the private petition that may not assert that either in civil action arising in whole or in part in Section 1338 of the Title 28 proceeding after the International Trade Commerce Mission under Section 337 of the Tariff Act 1930 with a claimant invalid with any of the ground petition raised and reasonably could have the raised during the post-grant review. Reissue patent post-grant review may not be instituted with the chapter petition request the cancellation claim. Reissue patent with the identical or narrow claim in the original patent from which reissue patent issued with the time limitation Section 321C when bar filing petition post-grant review for the such patent. Title 35 U.S. Code 326 content with the post-grant review. The regulation of the director shall prescribe the regulation provided by the file. Any of the proceeding with the chapter shall be made available to the public except for any of the petition with the document filed with the content of the seal shall, if the company the motion, seal will be retrieved with the seal for the pending and outcome of the ruling of the motion with set forth and seen by the showing with the substation grounds to institute with the review under subsection A or B of Section 324 establishing proceed with the submission supplemental information with the petition is filed. Establishing governing post-grant review under the chapter relationship to such review other than proceeding under the style setting forth standard of the procedure to discover the relevant evidence, including the discovery shall be limited to evidence directly related to factual assertions of either party of the proceeding. 6. Prescribing section of the abuse, discover the abuse of the process of any other imposed of the proceeding of the harass or to unnecessary delay unnecessary will increase the cost of the proceeding. 7. Providing the protection for the order for the governing and exchange and submission confidential information, providing filing with the patent owner with the response of the petition with the Section 323 post-grant review have been instituted with the requirement of the patent owner with filed with such response with the last affidavit, the declaration of additional factual evidence, the excerpt, opinions on which patent owners rely on support of the response. 9. Setting forth the stream of the procedures allowing patent owner to move the amendment of the patent owner Section D with the cancel the challenge claim, the purpose of reasonable the number of the substitute claim concerning the information submitted by the patent owner support of the amendment entered into the subsection D with it made available to the public as well as the prosecution history of the patent. 10. Providing either party with the right to oral hearing as part of the proceeding required with the final determination post-grant review issued later than 1 year after the date of the director not in was instituted with the proceeding on a chapter with except for the director made with a good cause shown within 1 year period and no more than 6 months of the may adjust the time period of the paragraph in the case adjoined under Section 325C. Providing the petitioner with at least one opportunity with a written comment of the time period established for the director. B. The consideration Prescribing regulation section, the director shall consider the effect of the regulation, economy, integrity of the patent system, efficiency, administration, officeability of the office, timely complete. Proceeding instituted under chapter, petition, trial, and appeal board, patent trial, appeal board in accordance with section 6, conducted each post-grant review instituted with the chapter. D. Amendment of the patent in general of the post-grant review instituted under the chapter of the patent owner of the file one motion amendment of the patent one or more following ways cancel the shall and patent claim for each shall and claim purpose of reasonable number of the substitute claim. Additional motions to amend the permitted of the joint request for the petition patent owner material advance for the settlement of the proceeding under section 327 and upon request for the patent owner of the good cause showing support scope claims amendment under the subsection not in large scope of the claims of the patent entry of the due matter. Evidentiary standing post-grant review institute with the chapter petitioner shall have the burden of proving the plaintiff's proposition on patentability preponderance over the evidence. Title 35 U.S. Code 327, the settlement in general, the post-grant review institute with the chapter terminated with respect to any petition of the joint request of the petitioner patent owner unless the officer would decide the merit of the proceeding before request termination shall the post-grant review with the terminated with respect to the position with a section of the notice estoppel in section 325 of the shall attach the position of real party interest deprived of the position on the basis of the position institute with the post-grant review. No petitioner with a post-grant review office may terminate post-grant review proceeding the final written decision under section 328A. Agreements in writing and agreement of understanding between the patent owner and petitioner, including collateral agreements referred to in such agreement that understanding the made connection, contemplation, termination, post-grant review under section shall be written. True copies of such agreement that understanding shall be filed with the office before the termination post-grant review between the parties that request of the party proceeding agreement that understanding shall be treated as business confidential information shall be kept separate from the file of the involved patents and shall be made available to the federal government agencies on written request to any person showing good cause. Title 35 U.S. Code 328 decision of the board, final written decision, post-grant review institute with the dismissal of the chapter patent with the trial appeal board shall issue the final written decision with the respect for the patentability, any patentability change for the position, any new claim added within section 326D. Certificate Patent Trial Appeal Board issue the final written decision on subsection A with the time when the for appeal expire without any appeal with the terminated director shall issue the publisher certificates canceling any claim of the patent file when terminated unpatentable, confirming any of the claim determined with the patentability, incorporating patent obturation of the certificate and new and amended claim determined unpatentable. Intervening rights are proposed amended with a new claim determined patentable incorporated patent following with a post-grant review of the chapter having the same effects specified on the 252 reissued patents right at any of the person made with the purchase of the United States import of the United States with anything patent in such purpose proposed amended new claim or which made substantially preparation thereof the before issuing certificate under section D. Data length of the review office shall the mail available to the public data describing the length of the time between the institution issuing the final written decision on section A each for the post-grant review. Title 35 U.S. Code 329 appeal party dissatisfied final written decision patent trial appeal board under section 328 may appeal the decision pursuant to 141, 144 any part of the post-grant review shall have the right to party appeal and Part 4, Patent Cooperation Treaty, 35.1, definition that when even is proven unless the context otherwise, the term treaty means a patent cooperation treaty done in Washington June 19th, 1997. The term regulation capitalized means the regulation treaty done in Washington on the same date as the treaty. Term regulations when not capitalized mean the regulation established for the director under the title of the term in international application mean the application filed under the treaty. Term international application originating in the United States mean the international application filed with the patent trademark office while acting in the receiving office of the treaty, irrespective of whether or not the United States has not been the designated of the international application. The term international application designating the United States means international application specifying the United States, the country of which the patent is sought with regardless for the stuff the international application is filed with. The term receiving office means the National Patent Office of the Intergovernmental Organization receive the process of the internal and national application prescribed by the Treaty of the Regulations. The term International Searching Authority and International Preliminary Examining Authority mean with the National Patent Office of the Intergovernmental Organization appointed with the Treaty of the process of international application prescribed by the Treaty of the Regulations. The term International Bureau means with the International Intergovernmental Organization recognized with the coordinated with the body of the Treaty of the Regulation. Term expressed and not defined by the part are to be the same as indicated by the treaty and regulations. Chapter 36, International Stage.